with me, civil attorney, former prosecutor Kirk Davis. And Kirk, you know, there was all kind of contradictions with this guy. You heard the statement he was making to police there. You know, it seems as though he wants to give his story, tell the truth. He wrote letters to his children, which kind of contradicts some of the things he was saying, talking about, you know, me and your mom, I'm going to take your mom's life, I'm going to take my own life. You guys can move forward with your lives. You're better off without us, et cetera, et cetera. What did you make of that statement to police and how this all played out in the trial?
Well, I mean, he's, again, you know, I think you know the expression, a person who has an attorney who represents themselves as a fool for a client. And I think the same thing applies to folks who are pro se. So here he is, even at this time, under the interrogation of the detectives, and he thinks apparently he thinks he's smarter than everybody else and thinks he can kind of smoothly talk his way out of it. So certainly he is trying to present himself in the best light, like, yeah, I tied her up and put the pillow over her face, but I didn't, you know, I was just trying to scare her. I really wasn't trying to kill her. Well, he did a pretty good job of scaring her, because she certainly believed it. So, I mean, he's trying to do the best thing he can to present himself in the best light, but the evidence in the case, as the prosecutor stated in her closing argument, is pretty overwhelming.
Yeah, and I agree with you. I think part of the problem with his statement was, and you're exactly right, it sounds like his tone suggests that he's trying to cover up his actions, make them seem more innocuous than they really were. I want to take a quick listen. We talked a little bit about the possible abandonment defense, and I mentioned that he had made an argument during a motion to dismiss the charge of attempted murder to the judge. It was ultimately rejected, but I want to take a listen to that, then discuss. Let's listen.
You are still requesting abandonment, even though you previously indicated to me that your legal position is you never intended to do it. Is that correct?
Yes, I'm still requesting abandonment of purpose.
First and foremost, Judge, the defendant has already stated during his previous judgments of acquittal that he did not intend to commit the premeditated act of killing Miss Mathewson. That alone, in and of itself, does not allow for an abandonment defense. As Your Honor has already pointed out, how can you abandon something you did not intend to do?
Your Honor, again, I have not testified to trying to kill anyone. The evidence only shows the statement by the victim, the involuntary statement by myself. Both show that a pillow was put over her, but it doesn't say to kill her. In my defense, it doesn't say just to kill her. It could have been to just keep her quiet. It could have been for something we were doing in the bedroom. But the intent to kill somebody has to be easily recognizable.
With all due respect, Mr. Summers, I'm denying the request to give an abandonment instruction.
All right, now, Kirk, you saw that the judge denied. He wanted that abandonment instruction for the jury. And the state made an interesting argument. They said, you know, you already said that this is not what you intended, so how can you abandon something that you didn't intend? You never intended to murder her. What do you make of that argument? It's a little technical, but hopefully you can sort of dig down on it and help us understand what the prosecution was getting at.
Right. I think that they're saying it's mutually exclusive. Either you intended to commit the murder, and therefore you would be allowed the defense of abandonment once you are in the middle of the act and sort of realize, you know, I can't go through with this, or whatever thought occurs to you, or maybe I'm going to wind up in prison. Whatever that thought process is, that the act or the commission of that crime is abandoned, as opposed to you never forming that intent to commit the act of murder or commit the crime of murder. And so it was always just, I'm going to put the pillow over her face to keep her quiet or to try to frighten her, but never forming that intent to commit the murder. So I think they're trying to say these things are mutually exclusive. You can't have both of those defenses.
Yeah, fair enough. And, ultimately, this jury saw all those pictures we were just looking at, all the damage he did to this woman, making it very clear that, whatever his intentions were, this was an ugly, ugly event. All right. Thanks to Kirk Davis. I really appreciate you joining me tonight. I always appreciate your insights. We'll see you again soon. We're going to take a break, folks.